The panelists who are with me tonight are the Honorable Justice George Zutrin and Lynn Ryerson. These two have been chosen particularly because their backgrounds may offer us different views on the family justice system that will spur our discussion this evening. Justice Zutrin began his career in 1978 after graduating from law school at Osgoode Hall. In Ontario, family law reform was just beginning in the late 1970s when Justice Zutrin graduated from law school and was starting his career. As a practitioner, the Law Society of Upper Canada certified him as a specialist in family law, and he's taught family law at the Bar Admission course in Ontario and participated in the process of certifying other lawyers as specialists in family law in Ontario. He was elevated to the bench in 1993, and as a judge, he's worked in two separate sorts of family law courts, and he'll talk about that further this evening. He's also participated in the court's work in dealing with matters such as unrepresented litigants, judges' use of technology, court rules, judicial ethics, and judicial education. So in addition to his experience in a province which has laws and procedures that are different from ours, he currently deals with family law and family justice in a court context. Now, in contrast to his experience, it's going to be that of Lynn Ryerson. Lynn began her career in practice of law right here in Nova Scotia after graduating from law school here at Dalhousie, and she's regarded as one of the most experienced family lawyers in the province. In 2005, she was appointed Queen's Counsel, a designation that acknowledges the contribution she's made to the practice of law in the province. She's taught family law at national continuing legal education conferences. She's chaired the National Family Law section of the Canadian Bar Association and worked on important law reform issues such as the child support guidelines. So in contrast to Justice Zutrin, her experience in education takes place in this province, and it followed much of the family law reform that occurred here. So we've got that sort of juxtaposition happening as well. And as well, her experience is outside of the confines of the court. While Justice Zutrin may speak a great deal about what happens in the court context, what Lynn Ryerson will be able to do is to talk to us about family justice outside of the courtroom in the context of arbitration and mediation. Since his lordship is from outside of Nova Scotia, his perspective will be informed by a family justice system that is not identical to ours here. But we will have a chance to compare and contrast legal systems that are similar but not identical, and this should add to our appreciation of that issue. I'm going to start by giving each of the panelists 10 minutes, and I'm watching the clock, to address as many, some, or all of a number of questions. And the particular questions are, should the public trust the family justice system? When families are in crisis, can current family law processes meet their needs? Can the public trust the system to deal fairly with children in crisis, custody and access issues, and financial support at the end of a relationship? And is there a trust that the system will work for those who need it? Since Justice Zutrin is our company, he's going to get to start first.
Perhaps based on some of what I'm already sensing as some of the responses based on the questions that are being put, I should start by commenting on there's a number of other colleagues, Nova Scotian colleagues that I see in the room, and I don't suppose to come here into Nova Scotia to suggest that I would know any better than any of the very fine colleagues that I see here. And I wondered to some degree why I would be asked to come from Ontario to speak to Nova Scotia, where there's such a fine tradition of courts and judges. But I can understand why. I've always respected the court here, and I know that the court reforms that have taken place in Nova Scotia in some ways are very similar to the court reforms that have taken place in other jurisdictions. Now, I'm going to say something perhaps somewhat obvious about what I'm about to say, and that is family law, like no other law, is so far different than every other law, and that the emotions that run so high makes family law unique. I know I've watched and I listened to Justice Abella's opening comments, and I know that you've had Justice Watts of our court speak here as well on criminal, and I don't know who the speaker is on civil. But let me say some things that perhaps might be too obvious about family law and how unique family law is. family law brings with it two people usually, and sometimes more, who are not strangers. These are people who come to our court often who have had a short or long-term relationship, who've had children, and who have a lifetime of experience with each other. And because of certain things that have happened to their families, whether they're separated or some other issues that have come up, they come to the court because they themselves are unable to resolve their issues. Unlike some other issues that come to court, these people, or the individuals who come to our court in family law, are not people who are dealing with a single incident, a car accident or a criminal act. It is some people who have had perhaps a lifetime of issues between them, and for whatever reason, they come to the court because they themselves are unable to resolve their issues. That comes with it a whole different set of realities, and what they come to is they come to a justice system or come to a judge like myself because they themselves, who probably know each other far better than anybody else and know their children far better than anyone else, are unable to resolve their issues. The question then is, how do we in the justice system respond to that? And the answer to that is that we can't cure all the issues that have brought them to that court. What we attempt to do is to do the very best we can, given the resources and given the information that we are given. Recently, I attended a conference on domestic violence, and somebody brought over an illustration of perhaps, I think, something that is consistent with the differences in family law. What they did was they drew a pyramid. You might have seen this analogy before. And in the pyramid, there was a cone. Do you start to get the picture? And in the pyramid, there was a hole on one side of the pyramid and a hole on the other side of the pyramid. And the question then was, if somebody was looking on one side of the pyramid inside, what did they see and what did the other person see? They all saw the same thing, but because they saw it from different angles, they had different truths as to what was going on. Now, a judge is supposed to, hopefully, have that pyramid removed so that we all can go around and look at the entire picture. Now, the reality is that we can't possibly ever get enough information to really know what was going on in that family. And what we do is we rely on the evidence of people, and we rely on the expertise of other people to try to do the very best we can for the family. Now, what has happened over the years is that the process in family court, in family law, has changed a great deal. Let me talk about very simply, and I'll start with this notion, is that the rules we've had, as Elizabeth has reflected upon, that in the 80s, federally and then provincially, we had a lot of amendments to the Divorce Act and family law legislation. But what has dramatically changed is the court process itself. That is, the rules of the court has recognized that what we should be putting on the emphasis in family law is not the trial at the end of the day, but how do we get people to resolve their differences, being better educated, better informed about the impact on families, on children. How do we get them to come to their own solutions? Not about the trial at the end of the day, because if we need to, we will have a trial. That's what a judge is there for at the end of the day. I spend my time, I would say 60 to 70% of my time doing non-trial work. I spend 60 or 70% of my time trying to get people to resolve their cases. Now, that's non-traditional judging. When I first started in practice in the early 70s, essentially, as a lawyer, I would either go to court on a motion or I would go to court to do a trial. And the judge's role was simply to decide the motion that I brought, which was for temporary relief, or to decide the trial at the end of the day on a final basis. And that's generally speaking what the judges did. We then introduced what we call settlement conferences in Ontario. Hamilton, where I practiced, was the first city in the country to have a unified family court. And what we introduced was a very simple notion. Before you go to trial, you have to have a settlement conference. And that was the only case management that existed. So what you had was, before you went to trial, you met with the judge for the purpose of trying to settle your cases. Well, our system has perhaps, some might argue, become too complicated, because what we've now attempted to do is to say to people, you can't even come into the courtroom without first having a case conference with the judge. And the purpose of that is to say, we don't want you to exchange ugly affidavits. I called it ugly affidavits. So the initial process in the 70s, and probably well into the 80s or 90s, was that two people separated, and one party would go to their lawyer, and they would draw up the ugliest affidavit they could possibly draw up. And what they would do is they would tell in an affidavit form everything terrible about the other party and why they shouldn't have their child, why they should be removed from the home. And on 4 days' notice, they would serve the other person, and on 4 days they would be in court, and the other person would see this document and say, I don't even remember back in the 80s, but I'm told that in 1980 I took my fist and put it through the wall. I'm told that I burnt the dinner, whatever else it is. And on 4 days' notice, the other side was required to do another affidavit. In the 1990s, we had what they call civil justice reform in Ontario, and people talked about this. We had public hearings, and they talked about the fact that the thing that they remember most about the family system was that this 4 days after they separated, the first time that they see the other party, they get this affidavit. They thought they were doing pretty good, except that they came home one day and all the furniture was missing. But they came home, they were served with these papers and an affidavit, and they responded in kind, and off we were to the affidavit for us. So there were efforts made to try to stop that. I don't know if we've been successful or not. I think we have been to some degree, but the system now is you are not permitted to do an affidavit. You're not permitted to start a case with a motion. What you have to do is ask for a case conference before a judge, and you have to put out the bare facts. When you were married, when you separated, when you started living together, if you weren't married, do you have children, how old the children are, where they go to school, what are your issues? Not about the terrible things the other person did. You can't ask for relief of the court at all without first having a case conference, which is an attempt to have a neutral evaluation. And that's the process. Now, there are exceptions to that. If there's an emergency, or if there's somebody at risk, or if there's some child at risk, a person at risk, then you can bring a motion, and you still might have these affidavits. The reason I'm mentioning this is that what has changed most dramatically in family law, in my view, is a recognition, and I think it's across the country, because I spoke to, for example, Justice Williams and I had lunch today, and I wanted to know or understand the differences between our practice and the practice in Nova Scotia, because I understand you don't have exactly that same practice, but I bet you that most courts in most places recognize that we make efforts to try to come up with a system which it isn't that the judge's first contact with people in the family system is where we kick somebody out of their house or we remove their children. No, I'm not talking about child protection for a moment. I'm talking about in the matrimonial context, where we attempt as much as possible to try to have people come to their own resolution. Not that there isn't laws, because we want to make sure that people understand whatever recommendation a judge makes is based on law. But what we attempt to do is, if it's at all possible, is to take out the emotional impact on people when they first separate. I'm going to stop very brief in a moment because child protection is a completely different set of issues and very important issues. I think you would all agree with me, those of you who are familiar enough with the system, and I speak anecdotally. I don't have absolute firm numbers on this. My guess would be that 95 to 97% of all cases settle. No matter what we do, 95 to 97% of the cases settle. It's 3% of the cases, maybe 5% of the cases that end up in trial. We spend, I suspect, 95% of our time talking about 5% of the cases, because those are the 5% of the cases that receive all the media attention. They're the high conflict cases. They're the difficult cases. And one of the things that I've never been able to do, and I know we have a written decision, at least by Justice Williams, that I've been given to, is that one we have never been successful in doing, I've never been successful, is to make a person who's difficult not difficult. I can't order them to be a nice person. I've never been able to enforce that. I've never been able to change that. If the expectation is that a court order can make a person different than who they were, we have never had any success. So what we attempt to do, I think the process we're attempting to bring about in family law is to get people to recognize that it's far more important to get them to resolve their cases themselves, understand what the law is, understand what is involved, and know that to allow a stranger like myself or any judge to understand fully their families in a brief, it could be a motion for a half a day or a half an hour or a trial even for a week. Life, as people said, is a motion picture. It's not a snapshot. What we get in court is a snapshot. And I think the expectations should be understood as to what we want to do. In the years that I've practiced, we've had a whole lot of different terminologies come about. We have family law information centers. I don't know what you call them here. We call them FLICs back home. It's an attempt to help people understand, if they choose to act for themselves, what's involved. So if they choose to act for themselves with family law insurance. Do you have parenting coordinators here? This is a new terminology, and that is, if people are high conflict people, we assign people to them who have the responsibility of making the decisions as to whether or not they pick up the children half an hour earlier or half an hour later, rather than have them come back to the court system all the time. We say to them, here's your person, here's your parenting coordinator, and this person, if you can't agree on who puts the skates on at hockey, this person will decide for you. But don't come into the court system necessarily to do that. That's a parenting coordinator. We've had, these are terms that didn't exist before when I started, whether it's the Family Law Information Center, parenting coordinator, self-help kits. I don't know what the percentage is in Ontario, and it may be different in the Unified Family Court, where we do all areas of family law, than it is in the Superior Court non-family system. But a good half of the litigants, I suspect, that we see are unrepresented litigants, people who choose to represent themselves. I heard statistics, for example, one time in Arizona, for example, and this is all universal, that in Maricopa County, Phoenix, Arizona, the percentage was as high as 97% of the people were unrepresented. And I think that I have over time evolved my thinking about self-represented people. My view about self-represented individuals is this: the vast majority of self-represented people are there because they actually trust the justice system, and they believe they can do just as good a job as a lawyer. And you have to step back and ask yourself the question as to what. I think that's the vast majority. There's another group of people who don't trust anybody, and who believe that nobody can tell their story any better than they can, and they have some other reason to come to court to be self-represented. And there's another group of people who the cost of litigation is so high that they can't afford it. And I think that the justice system has responded differently to self-represented today than they have initially. I think the recognition now is that, to some degree, the self-represented individual in the United States is called pro se's, are a reality in the family court system. And frankly, as I think you would recognize, and those people who do non-family work, self-represented doesn't exist only in family law. That's where the majority exists. Is that the court system has responded by recognizing that it is best to provide as much assistance as is reasonable to the self-represented, to allow the system to act fairly and properly. Not to give legal advice, but to allow self-represented individuals to understand the process and what's involved. And that's been the response, I think, in most jurisdictions to the self-represented. I'm told that I will end on the self-rep for the moment and allow others to respond. Thank you very much.
Thank you. And Lynn, I did want you to pick up and to deal with the questions I've asked. And if you have anything to say on the point of self-represented individuals in the court, in terms of your remarks, I'd certainly be interested in hearing that.
That's because it's my pet peeve, and she knows that. I'll talk for 10 minutes, but I'm very interested to hear what people in this room have to say, because the combined experience and wisdom in this room is several times my lifetime when I look around. And the opportunity tonight to talk back and forth between people here that know about the justice system is probably in some ways very unique. The question of whether the public should trust the family justice system has two aspects to it. There's a process aspect and a substance aspect. I'll talk first about the substance aspect because that's the part that most of the public focuses on when they talk about the family justice system. And the questions about substance usually relate to something we call bias. Is the judge biased? Judges are human, and that's a good thing, because we're looking to judges to make decisions in a setting where they have discretion. It's not something a computer can do for us, particularly not in the family law context. Not that they could in other contexts either, but in particular in family law. So what is discretion? Discretion in a dictionary is good judgment. Notice that that term has a qualitative piece to it. Sound judgment. The power of choosing is discretion. And we're asking people, we're giving people the power of choosing, because we, as a litigant, can't seem to make those choices ourselves. So part of the substance of what we get from the family justice system is about allowing someone else to make fundamental choices in our life, and then whether we're happy with what they do. In a dictionary, the opposite of discretion is thoughtlessness, recklessness, tactlessness. I'm not sure how tactlessness fits in there, but I thought it was pretty interesting, because that's a piece of it too. Judge's discretion is how individual justice happens. Ostensibly, everybody wants a judge that's free of bias. In my experience, what they actually want is a judge that has a bias in favor of their view. And very often, litigants don't like it when the judge doesn't have a bias in favor of their view. For example, a bias for or against shared parenting. I do want to say that in the ensuing discussion, if we get talking about that when I talk about bias, I'm not talking about informed opinions based on social science research or judicial experience. I'm talking about bias. Bias is, in a dictionary, prejudice, preconceived idea, a narrow view, intolerance. In a legal dictionary, it's a preconceived opinion. It's a condition of mind that sways a judge so that the judge is unable to exercise his or her functions impartially in a particular case. Not having an opinion based on social science research that supports a certain way of dealing with a family in a particular context. And I think that's really important to keep in mind when we talk about bias, because when you talk about the public's trust in the family justice system, you invariably get into whether the judge was biased. The question is whether the system operates in such a way that the outcomes are fair. Do they reflect sound judgment? In order for decisions in a family context to be fair and reflect sound judgment and instill in the public trust, there are certain attributes that the judges sitting in the court need to have. And I want to reiterate something Justice Sutran said. Most cases settle, but they settle in the context of what a judge would do or what a judge does do outside of a trial process. Our family division judges, the hard work they do, the hardest work they do, from my perspective looking at that court, is in settlement conferences, organizational pretrials. Once you get a case to trial, the 3 or 5% that simply can't work their way through a different process and they're making a decision in trial, I'm certainly not suggesting it's easy. I wouldn't want to be doing it. But it's not as hard as what they do before they ever get there. And certainly even the cases that never get in front of a judge, even in a settlement context, are settled in the context of what a judge would do. So what is required for the public to have trust in the family justice system? What is required from that judge? It seems to me that judges, good judges, judges that instill trust in the system, are intelligent, they're humble, and they're free of bias. And that's the same in any kind of work that the public asks anyone to do, really. I have a limited experience because I practice only in Nova Scotia. But my experience here is that intelligence on our bench is very common. It's not universal. Humility is maybe a little less common, but it's there. And free of bias is by far the most usual experience that I have. My clients don't necessarily think the judge is free of bias. Get back to my comment. What they're really looking for is a judge that is biased, in fact. Okay. So I think that we should talk here, questions can be raised here about how these issues of judgment and bias reflect the trust the public has in the substance of, in the outcome of the family justice system. Process questions are related but quite different. And in my view, the process questions relate to accessibility and due process. Accessibility is a resource issue. It's a resource issue, it's a judicial and related resource issue, and a large part of it is based on financial allocation, which the judges have, I assume, little or no control over. And so accessibility to the family justice system is different in different parts of our province. We have an incredibly responsive family justice system in Halifax. I think we have a somewhat less responsive and by far less well-funded system outside of Halifax. And you'll find the same in the medical system, and you'll find the same in lots of other areas where we are competing for resources, financial and other resources that are scarce. In some aspects, our system is grossly underfunded, even in Halifax. In some aspects, it's not adequately funded. But we have judges that work in that system and staff that work with them that provide an incredible resource in terms of accessibility in Halifax, for sure. The separate question of due process, again, relates to something Justice Zutrin was talking about. Due process is not just about how the trial is run. Due process deals with a contrast between speed of response and giving enough time for people to adjust. Justice Zutrin talking about the affidavits on 4 days' notice. It was like the Wild West in chambers, you know. You could file anything. A judge didn't like it, but we did it. And we don't do that anymore, and it's far better that we don't. In my experience, in my practice, if I have clients coming in the door on day one and I can put a Band-Aid that holds blood for 6 or 8 months, it is a totally different process 6 or 8 months out. I won't be fighting over any of the same kinds of things. I won't even be negotiating many of the same issues if we can just put a Band-Aid on for 6 or 8 months. In many, many situations, the Band-Aid has to be adequate. And that is the same with our system. Due process isn't all about how fast can you make it happen. It's about speed of response where necessary versus giving people enough time. Ending briefly on self-represented litigants, I'm really glad that I'm not a judge having to deal with them, because it's incredibly frustrating as counsel dealing with a court that has self-represented litigants getting special treatment from the judges and parties hiring counsel who really don't have any choice but to decide how they're going to deal with self-represented litigants. And we spoke while we were having dinner earlier about this issue, because it's all very well for counsel to say everyone should be treated the same in the judicial process. That would not provide public trust in the family law system. You simply cannot treat everyone the same, whether they have counsel or not, based on their experience, their personal experience, their intelligence, their ability to present their own case, whether their counsel is junior or senior. And if if nowhere else in the system, in the family justice system, the stakes are simply too high to just assume everyone gets the same treatment, although I will ever deny saying that when I'm over there complaining about how self-reps get special treatment at the family division. I think that's basically what I wanted to say before we have our questions.
Well, in the first questions, I told both panelists that what I wanted to do was give them a bit of a chance to respond to what each other has said, because while we did have a general conversation earlier this evening, neither of them have actually heard each other's remarks until now. One question I wanted to ask Justice Zutrin about what Lynn Ryerson has had to say is, what do we do about situations where one person comes to court with their lawyer, the other person comes to court without, and the judge is in the position of having to assist the person who does not have counsel and may thereby create the impression by the person who does have a lawyer that maybe the judge is biased in favor of the person who does not have a lawyer. So how the judge and how the system responds to a concern about, is this fair? Should I trust what's going on here?
I didn't want to leave the impression by what I said earlier that it's an easy situation on the self-represented. As judges, and I know that there are others who might comment on it, who might later on have questions, I suspect that for myself, I would prefer two self-reps, both sides, rather than one self-rep and one counsel. My biggest preference is two well-represented parties with two very good counsel, well-prepared, reasonable, rational, presenting a great case.
Litigants or the counsel? Reasonable.
I think both. I think both. And frankly, those are the ones that are the 97%ers or 95%ers that settle. Now, and I know that there's been recently, and it's published now, the Canadian Judicial Council has recently set out some, I'm not sure how I should put it, guidelines. If you reproduce it, I just want to call it the right document.
Right there. Statement of principles.
Statement of principles on self-reps. And I'm just a lowly trial judge. And the reason I say that is because when we deal with cases with self-representatives, it's not uncommon that you see the next time in the Court of Appeal in which the Court of Appeal then reviews how we handled the self-rep and tells us whether we've done it right or wrong. And then I think, as Elizabeth said, I was on a committee with two other colleagues when Justice Lesage asked us to help judges on how to deal with self-represented litigants. Now, my view of self-represented litigation is that we should explain the process to self-represented litigants, but we shouldn't tell them what the law is in the sense of if they want legal advice, they should get legal advice, seek out legal advice. My view is also that we should make available to self-represented individuals the ability to find that out so that the family law information centers, the self-help kits out there. But I think it becomes very difficult for a judge sitting on the bench, and frankly, I'll give you my view of how I deal with this. As I said, most of our time is spent doing either conferences of one sort or another, settlement conferences, trial management conferences, case conferences. And if I have a self-represented individual and the person on the other side is represented, I make it absolutely clear to the self-represented that I'm not there as a substitute for them having a lawyer. I'm not there to give them legal advice. I will let me give you an example. Let's say we're doing a trial. It's perhaps an easier example. I will say that if they're the respondent, here's what's going to be involved in the trial. The applicant will present their case. They will present witnesses. They might have an opening statement. They can decide what to do about an opening statement. Then I will tell them that when the witnesses are called, they will have a right to cross-examine. There may be objections to the questions. I will rule on whether their questions are appropriate. I will explain what will happen in court and how the process is. I will encourage them, even at every step of the way, to get counsel or to seek advice elsewhere. I'm not a substitute for their lawyer. I'm not there to give them legal advice in the sense of what to do and how to do it. I will explain the process. Particularly where there are children involved, I think we as judges have a higher duty to make sure that the process is extremely fair and that the decision is based on the best interest of the child, however you might want to interpret that, and to make sure that the evidence that I need to decide the case is there and that it's not missed because a person who's self-represented was unable to present their case properly. So in that case, I feel differently than perhaps when it's a property or a support case or something else like that. I want to make sure that the system is fair. I want to make sure that a person has an opportunity to present their case fairly. I want to make sure that they understand the process. And I think that's our obligation. I've had counsel many times say to me, but that's not being fair to us. One person is chosen to retain counsel. Well, I think the short answer is that you know the process. You're the lawyer. You should know the process. I don't need to explain the process to you. And I think what you hear often, because I've seen it, is that if I say to somebody, let's say a self-representative is speaking, on the other side, counsel will often stand up and say, Your Honor, that's not relevant, or why are you allowing them to talk about that? And I will often go like this. Don't worry. I can distinguish what's relevant or not relevant, even though you may be objecting. I know it's not an easy situation. My preference, as I said, would be to have self-represented individuals, not have self-represented individuals be represented. But as long as they're in the process, particularly in family law, I think my obligation is to make sure that the process is fair, regardless of the case. And I think that's the way it has to be.
In terms of Lynn, you responding to what you've heard, I wanted in particular to hear from you before we talk to people in the audience about the comment that 90 to 97% of cases settle, and we spend most of our time, 90%, 95% of our time, talking about the 3 to 5 to 10% of the cases that don't.
I don't think lawyers and judges spend 95% of their time talking about those 3%. I think the media spends 95% of its time talking about those 3%. Those are the 3% that get reported and that become higher profile. But I think that lawyers and judges understand that most of those cases are going to settle. However, they're settling in the context of what would happen if you litigated. What would the cost be, and what is the likely outcome?
I agree with that. I think what we've attempted to do is that there used to be this pyramid to say that we spent all our time devoting the time to the trials. And I think what we've attempted to do in the process is to recognize that we should be spending more of our time getting cases resolved earlier, fairer, less cost financially and emotionally. And I think that's what's changed in the system. I think if you would go back, and I don't know how far back you have to go, but a lot of judges would be adverse to the notion of having a round table discussion with litigants present in the court and having a discussion about how to resolve the case. I don't see the judge's role, I must say, as a mediator. I see the judge's role as a neutral evaluator. And so my view has always been that when I do a conferencing, what I tell people is that if the facts are presented as follows, my expectation is that the outcome may be as follows. So that what you come to, because if you want mediation, you can go elsewhere. I see my role as a judge is to say, here's what you presented to me. I think a likely outcome. If you want to go to trial, you may have a different view. But if we can get people in at an early enough stage, assuming that the information is available to make that evaluation, we should be able to provide that to people so without as much economic costs, as much emotional costs to them, that we can resolve their cases. And I think that's what's been the change in the process, is that we recognize that we need to devote as much time to the resolution of the case as we might have otherwise to the trial part of it.